everyone. I'm Jenny Wilson, a trustee of the Network for Responsible Public Policy. We're so happy that you joined us tonight. The Network for Responsible Public Policy connects people with thought leaders who educate and inspire. Tonight, we're going to return to Philadelphia and discuss amending the Constitution for the 21st century. We're so fortunate to have Beau Breslin, the Joseph C. Palamountain Jr. Chair in Government at Skidmore College, and Henry L. Chambers Jr., Professor of Law and the Arthur E. Owens Research Scholar at the University of Richmond. Our distinguished speakers' bios can be found on our website. Throughout tonight's conversation, we encourage you to post your questions in the Q&A box. Beau and Hank will endeavor to answer as many as possible toward the end of tonight's discussion. Beau and Hank, thank you both so much for being here. Let's get started.
Great. Thank you so much, Jenny, for that warm and generous introduction. I need to do a couple thank yous, and then Hank and I will get into the conversation. To Jenny, as I said, thank you so much for introducing us. To Rhoda Shermer and the wonderful folks at the Network for Responsible Public Policy for reaching out in the first place to Hank and me. It's been, I'm super excited. I know Hank is super excited about the opportunity to work, to collaborate with the network. And the work that you all do is crucial to America's future. So we absolutely appreciate and thank you for that. I'll thank Hank. Hank Chambers, whenever I'm in Hank's orbit, I feel a bit like an intellectual fraud, a brilliant legal scholar if there is one. Hank has taught me an enormous amount about the Constitution and about the law. And so it's really an honor and a privilege to share the stage with Hank. And you, the audience, thank you for taking the time out of your day or evening or to engage with us on this most important topic. So let's get started. We live in exciting times, exciting political times. They are exciting for the obvious reasons: upcoming election, partisan bickering, political polarization. But they're also exciting for less obvious ones. And the ones that Hank and I want to consider today, the one that Hank and I want to consider today is probably a little bit less obvious to most Americans. But I would argue the idea of constitutional reform is as crucial as any in our current republic. This is a project of improvement, right? America is constantly trying to form a more perfect union. And the questions that we face today are, how do Americans fulfill the promises of liberty and equality and justice, peace, and so on? These are questions that Hank and I have spent the last 20 years thinking about. And thankfully, a lot more people have thought about them more recently. The idea that we aren't a perfect union and that we should maybe think about constitutional reform in order to achieve closer to those promises. You have the National Constitution Center do a constitution drafting project. You've got The Atlantic coming up with a journal edition on to reconstruct the nation. You've got books that talk about constitutional reform. Some of the most famous ones, Larry Sabato's book on A More Perfect Constitution, What Changes Are Necessary, and so on. So people are talking about what constitutional reforms are necessary. And our goal in today is to think about constitutional reform in the 21st century, a return to Philadelphia, so to speak. But we need your help. We need the help of the audience members. And so come along on this ride with us and think about how we might think about constitutional change, constitutional reform, and constitution making. And keep those questions coming. First, Hank and I want to talk a little bit about historical context, and then we'll get into the contemporary debate about constitutional change. But it makes a difference when we want to talk about where we're going. It makes a difference for us to think about where we've been. And so we'll spend a little time talking about the founding, not too much. Hank is an expert on the Reconstruction Amendments, and I will tell you the Reconstruction Amendments fundamentally changed the landscape of the American political regime. And so we want to make sure that Hank tells us a little bit about how that change came about and the promises that were either fulfilled or not fulfilled during the Civil War period. And then we'll turn our attention to contemporary questions of constitutional reform. I'll begin with the story, and this is a true story. It's a very brief story, but imagine it's 1787 and we're back in Philadelphia. The Constitution has just been drafted by what started out as 55 people and eventually was signed by 39 members of the Constitutional Convention. And James Madison, arguably the father of the Constitution or the main drafter of the Constitution, is worried a little bit about what his mentor and friend Thomas Jefferson thought about the text. And so shortly after September 1787, he ships off the Constitution to Jefferson and asks Jefferson what he thinks about the proposed Constitution. Jefferson's in Paris. He's not in Philadelphia. He would have been in Philadelphia if he had been in the United States, but he's in Paris. Madison wants to get his thoughts. Jefferson reads the Constitution, writes back, and says, oh, I like certain things about the Constitution, but there's one thing I really don't like, and that is that the text doesn't have a sunset clause. It doesn't have a mechanism for each generation to write its own Constitution. And he has this very famous line he writes to Madison where he says, the earth belongs to the living, by which he meant that each generation ought to write its own Constitution, because a generation that was beholden to a previous generation's vision for politics, constitutional vision for politics, is just another form of tyranny. It's like colonialism, right? You're being controlled and overpowered by a people, now a dead people, but a different generation's vision. And Madison writes him back and says, oh, no, Tommy, that's not what we're doing. We need a Constitution that extends over a long period of time, over generations, in order to build up credibility and legitimacy. They never agreed. Madison and Jefferson never agreed. And Jefferson, to his death, always thought that each generation ought to write its own Constitution. He thought it was every 19 years. But one question I have always thought about in my own work is, what if there was a culture of constitutional reform in the United States? What if Jefferson had won that debate? What if each generation had written its own Constitution? That we'd be in a very different place, because now our Constitution is 230 plus years old. It is in some ways perhaps outdated, and that's something we want to get into. But keep in the back of your mind the Jeffersonian idea of generational constitutional change. And I'm going to turn it over to Hank for a moment to talk about what is arguably the biggest constitutional landscape shift that happened as a result of the Reconstruction amendments in 13, 14, and 15. Hank?
Yeah, Beau, it's great to be here with you, and thank you all so much for joining us on the webinar. It's great stuff. I feel the need to jump off of what you said before we get into the Reconstruction time. We have to think about the question of time. So I want people to think about the year 2261. And folks may say, that doesn't even sound like a real year. That's not a real number. Well, just recognize that 2261 is 237 years from now. We're 237 years removed from the drafting of the Constitution. So if we think that it's crazy for what we say here to govern the United States of America in 2261, then surely we should think it's crazy for us to be governed by the understandings of a document that was written in 1787. Now, I realize that some people on the webinar may be clutching their pearls right now, but the notion is that's what we're talking about. So are we talking about writing a constitution for all time or no? So even if we don't take the 19 years per rewrite that Jefferson gave us, we could certainly say, well, we ought to either rewrite or restructure or rethink about the Constitution every 10, 15, 20 years, or every day. Because in some respects, what we have to ask is whether this is a constitution for the living or not. Now, Beau wrote a great book that, if I remember correctly, is called A Constitution for the Living.
It is.
And that's a part of the notion that what governs us is us, as opposed to the document. And I'm about to say something that's going to sound crazy to those of you out there who are lawyers, and that is, we have to ask ourselves whether the document is a legal document or a political document or an historical document. And I know that some folks would say, well, I don't understand the difference between them. So let me just note, if we think of it as a legal document, for us lawyers, that tends to mean that the document meant what it meant at the time it was drafted. So it's relevant to ask, well, what did the folks who ratified the document mean? And recognize that I say ratifiers, we could talk about framers, that is, we could talk about Madison and the folks who were at the convention, or we could say, no, they wrote it. The folks who ratified the Constitution were the ones who actually gave it meaning. That is to say, what the document means is what ratifiers or regular people thought it meant at the time, not necessarily what the people who wrote it meant. You know, for anyone who has written an email to a friend that has been either mischaracterized or misunderstood, you know what I mean. You know, so those are pieces of the puzzle. So we have to think about what the document is. If the document is a political document, then it's got a lot of political principles in there. And the notion is we should take the principles and move them into today. So when we read the preamble and we talk about we the people, first question is, who are we the people? So if it's a political document, then it's easier to put additional understandings into the document. We could just think of it as an historical document. That is, it's a very nice thing that was written at some time. So some of the language that was written 230 years ago should be thought interesting, but not terribly important. At least not language that should govern us. Interesting language, but not necessarily language that should govern us. So if we have different understandings about how the world should work today than they had 235 years ago, then it may make sense to just say, it's lovely that our forebears wrote it. Good on them, they were trying, but we've moved past that. So in the process of thinking about moving past it, possibly, then we can start thinking about things like the Reconstruction Amendments, which came about as a result of the Civil War. And yes, I happen to be in Virginia right now, so of course we'll do the joke about the War of Northern Aggression or the war between the states and that kind of stuff. But it was functionally a civil war, and of course I recognize that some people take that quite seriously. That is to say, their notion is, if you think about the United States of America as being a union of states, then it's not crazy to talk about the Civil War as being the war between the states, as opposed to a civil war. Right? Civil war usually means you have two sides fighting over the same territory. The Confederacy would argue we didn't want the North. Those states that stayed in the Union, you can have it. We just want the area where the folks who are in the Confederacy want to be. So that's one of the reasons why sometimes people quite seriously will balk at the notion of a civil war, because that's not quite what it was to them. Obviously, to the Union, well, it was a civil war in that you're fighting over territory that's the United States of America, so you are fighting over something that's ours. So those are interesting notions. Now, take that notion, a pre or antebellum notion, recognized that different people in different parts of the Union thought about the Union differently. Was the Union something that we have while we're all okay with being in it, or is it something that we have when it's still doing its proper function, when it's helping everybody? Sometimes I'll use the notion of a marriage. That is, was the United States a covenant marriage, or was it a marriage in a no-fault divorce situation, where the notion is, well, yes, we're married until we're not? Or is it, no, once we're married unless something extraordinarily important, something core to the agreement, something core to the Union goes sideways, and then maybe we can divide, right? Or is it, no, once you're in, you're in. You can't get out. It's like the Hotel California. Right? Check out, but you can never leave. So the notion of what the thing is extraordinarily important, because if we agree on what the thing is, then we can write a constitution to make sure that we move forward with whatever that thing is. If we have disagreement about what the thing is, then the document we write, it's going to be subject to a whole mess of interpretations. So part of the question we can ask is whether amending the document is about settling interpretations, or is amending the document merely about making sure that it's relevant for our time? And if it's the latter, then we have to look around and realize the document hasn't been amended, has not been literally amended in 32 years. And even that's a little bit of a cheat, because the 27th Amendment was first offered in, 1789, and was finally ratified 203 years later. So if we take out the 27th Amendment, I mean, I'm not saying literally we should, because it is an amendment, but if we went back to the last time we really had a goal of ratifying something that changed the Constitution, that was really the early 1970s. So we're about 50 years past the last time we really amended the document explicitly. Now, we've arguably done it implicitly with Supreme Court decisions, et cetera, but that's a little different story. But I realize I've been talking a while, and I still haven't talked about the 13th, 14th, 15th Amendment. But let me stop for a second there, because I swear I'll get to the Reconstruction Amendments. But I do want to see if Beau, do you have any thoughts and comments on sort of the general notion? Because you, as a political scientist, I imagine you may look at the Constitution as being more clearly a political document than folks in my area tend to, where we just go, hey, it's a legal document, that means it's ours, and y'all can't touch it.
Yeah, I mean, it's interesting, Hank, because of course I do look at it that way. I do look at it as a political document, but I've always been intrigued by a lot of the work that you've done actually on what I'm going to describe as fundamental principles of that a constitution is supposed to reflect those fundamental principles that we agree on, however we agree on what that means. And I'm going to put some, the rubber hitting the road. By fundamental principles, I'm talking about liberty, I'm talking about equality, I'm talking about justice, those things that are identified in the preamble, not always in place, amended in some senses and in some senses not. But to what extent does this Constitution today reflect in your mind those fundamental principles that we sort of equate with the legal document that is the Constitution?
Yeah. We're trying, right? One of the pieces of the puzzle is you have the document there, and one thing you have to ask is, who gives it life? Do we, the people, give it life? Or does the Supreme Court give it life? Certainly when when I'm teaching my students, or I should say when we're learning together, we look at a lot of court cases. And in many ways, my students will say, well, the Constitution means what the court says it means. And in some ways, they're absolutely right. That is to say, for example, Brown versus Board means what it means. The Supreme Court said Brown versus Board means X, and therefore the Constitution means X. And for the most part, people said, okay.
Right.
We can take it more recent. We could look at Bush versus Gore. When Bush versus Gore was decided, a number of folks were not happy with it, but they got really upset, and boy, did they tap on their keyboard to write op-eds. But they didn't take to the streets.
Right.
Now, obviously, we might well say, well, okay, what about January 6th? I think it's fair to say that the lion's share of people would say, well, but what happened on January 6th was not our finest day, because we don't really believe that the people in that way should give life to the Constitution. You can be upset, but work through structures in order to give the Constitution life. So we try to do justice, we try to do liberty, right? We try to preserve life, liberty, and property. We were going to say pursuit of happiness, but then we recognize, hey, that's the Declaration, which is a whole nother piece of the puzzle, right? Folks who say, well, the Constitution says X, and you say, well, actually, that's the Declaration, and they say, well, it's the same thing. Well, yeah, well, not quite. Now, I'm not saying that they're inconsistent, but they're not quite the same thing. The Declaration really gives us the basic principles. The Constitution says we're going to take our ideas, and this is how we're going to structure this organization in order to bring forth all the stuff we say matters. Hence the preamble. So do we try to do justice? Yes, we try to. Do we get it right? That's unclear. It's unclear from a substance perspective. It's also unclear from a structural perspective. So, for example, when we think about the Senate, the U.S. Senate, and how the seats are allocated, 2 per state. Okay, we understand that. Let's compare. Usually I'll go to Wyoming, but now I want to be nice to my friends from Wyoming. So let's go to Vermont. Vermont has just over 600,000 people in it. They get 2 senators. The Constitution says they get 2 senators, so by goodness, they get 2 senators for about 625,000 people. The state of California gets 2 senators for about 40 million people. Now, I recognize that the Constitution says what it says, and every state gets the same number of people. But now we can ask the question, is that justice? Mm-hmm. Well, if you say every state is the equal of every other state, then the response is, yes, that's justice. If, on the other hand, you say, we the people, starting the preamble, is meant to suggest that every person is equal, it sure is hard to say that every person is equal when the 40 million Californians get 2 senators and the 600,000 people in Vermont get 2 senators. And it doesn't matter whether the folks in Vermont are parallel or have the same ideas as the folks in California. That's not the point. The point is very different ways of allocating numbers. And I recognize people say, well, but what about the House of Representatives? Yes, that is true. The House of Representatives exists, and that's allocated more in the lines of population, but the House can't do anything by itself.
Yeah, so let's say now Hank, you're in Philadelphia. It's 2024. There are a number of proposals floated around for our a lot of people call the undemocratic Senate. Tell me which ones you think are are the most interesting or viable, or tell me which one you might support if you're a delegate to Philadelphia in 1787. Then we can move on to all, I want to hear about federal court judges and term limits and preamble changes and so on. But at least for now, tell me which one you might think is a good idea for the Senate.
Sure. It's such a great question, in part for a couple reasons. So let's unpack a couple pieces. One is, if we were going to have a constitutional convention, a new one, would we put it on the East Coast at all? It made sense for it to be in Philadelphia in many ways, because, hey, Philadelphia was close to where the action was, et cetera. So, but we could ask, should we put it in Chicago? Should we put it in Dallas? Right? Should we put it in California? So that's one piece of the puzzle. Should we put it in Washington, right, where the capital is? Now, if we're back in 1787, I think one of the questions we might ask is, if we think the Constitution will be around for another 250 years, how should we do the Senate? Versus, how should we do the Senate right now?
Right.
Because, of course, when you're coming off of the Articles of Confederation, where every state was treated as the equal of every other, and understandably, because they had all fought a war together, but also separately, the notion was you have to treat every state as being equal. I think today the question we would ask is, if we were thinking about doing it today, and it were a blank slate, because of course that's the other piece of the puzzle, is if we're asking for amendments to the current Constitution, then we're very limited in what we can do with the Senate because of Article 5.
Right.
If, on the other hand, we're literally saying we can blow it all up, now we start saying, hey, how about we do the Senate by population as well? And there's some people who would go, that's crazy, but hear me out on this one. Two pieces of the puzzle, one reasonably current, about 60 years old, and the other 237 years old. The one that's 60 years old is the Baker versus Carr cases, the one person, one vote cases, apply to each house of each state legislature. So the argument is, the state Senate in Virginia and the House of Delegates are both apportioned by population. They can have different functions because the sizes of the constituencies are a little different. In Virginia, we have 100 delegates and we have 40 senators. So the senators are representing 2.5 times the number of people. And the senators serve for 4 years, the delegates serve for 2 years. So the bodies do something different, but they are both allocated by population. So we could say, well, we do that with state government, so why not do it with the federal government? That's the 60 years, the idea from 60 years ago. The idea from 237 years ago, of course, is James Madison. His original plan was a Senate that was allocated by population. Now, you may say, wow, I never heard that before. That's crazy. Well, a number of folks said, yeah, that's a good idea, but that's a non-starter. We were equal under the Articles of Confederation. In some way, we need to recognize that we are all equal as states in this union because we're a union of states. The other is, folks had every right to look at James Madison and say, well, yeah, you're from Virginia, one of the two most populous states in the union. Of course, you want to do the Senate by population as well. And I'm sure he said, no, not me. I'm just doing what I think is best for the country. Okay, fine. So my take is, if we go to population, if we allocate the Senate by population, I'm fine with that. But the reason why I'm fine with that is because I don't look at states as really being serious parts of the union, except because we have a constitution that says they are. That is, if we were really going to blow up the Constitution, I think it's fair to say that we probably would not draw the same lines for states as we have now. And folks can say, no, we would, but no, I really don't think we would. I don't think that Kansas City, Kansas, and Kansas City, Missouri would be in a different state if we had no lines and we were drawing them anew.
Agreed.
There's no way California would be drawn as California is drawn if we had just new states. So that's part of what I mean when I say, hey, if we're blowing up the Constitution and we're just saying, what is the United States of America? And we say, hey, we're just this landmass, and now let's govern this landmass. I think we would have a U.S. Senate that did something different and would be allocated based on population. Now, if all we're talking about is distinguishing or going from the structure we have now, where every state has a governor, every state has a state legislature, et cetera, I think the best we can do is sort of top off and maybe give California a few extra senators, give Texas a few extra senators, give Maryland, New York, a few extra senators in order to give a little bit of an extra so that it's a little more based on population, but probably we're not going the whole way. But even that would require at least 2 rounds of amendments.
Yeah.
Because the first thing we'd have to do is amend the Constitution and amend Article 5, which says that no state can be denied its equal representation unless the state agrees. Yeah, have fun getting Vermont to agree to give up their equal sentence. So first we'd have to have one set of amendments to amend Article 5. Then after we amended Article 5 and took that out, we'd then have to amend again. But when we amended again, we'd still have to get 3/4 of the states. So number one, we're not amending Article 5. I mean, even theoretically we could, we're not doing it because there are going to be 13 states that say no. But even if we did that, we still probably wouldn't amend it the second time in order to actually give quite different numbers in terms of the U.S. Senate, because again, 13 states would stand in the way.
So
now
let me get the let me keep with formal structures for a second, but let me ask you about the presidency, right? So complicated. It's an imperial presidency, and as a political scientist, I've sat there, a 57-year-old political scientist, I've sat there and watched our president get to be the by far the most powerful, partly because Congress has more or less moved to the sidelines self-consciously. So how might we think about 21st century reform of the imperial presidency? Do we go with a single term as opposed to 2 4-year terms? Do we think about more or less power when it comes to domestic issues, foreign relations, and so on? How might we think about constitutional reform in the presidency?
Yes, it's a great question, great consideration. We have to ask ourselves what kinds of skills do we want out of the president? And how much power do we want the president to have? Do we want the president to be a 4-year king? Which is something it's fair to think about, or some would say a 4-year dictator. The sheer volume of power that the president has is enormous. Now, I don't want to be unfair, because it's not like Congress was sitting around for 12 months out of the year in 1789 and saying, hey, we're always in session. They would go out of session for months at a time. So I think what happened, or what the real issue is America is just so much larger now. It's so much more complex. We have so many more agencies. There's so much more power that the federal government has. And if the federal government has that power, and the only person we have who was elected from the nation as a whole is the president, well, the president's going to need to exercise it. So one of the things we can ask is, is the job too big for one person? If the notion is no, the job's not too big for one person, then I think that person's going to have a ton of power. Now, is there some way for us to move away from that? Well, we could have a plural executive. I mean, we could say executives will have 2 or 3 people who will do 2 or 3 different parts of the job. You could have a foreign policy president and a domestic president. You could very well put far more power directly in the hands of the heads of departments. So your Secretary of Agriculture, your Secretary of Commerce, your Secretary of Labor could have far more explicit power, as opposed to being folks who report directly to the president. You could restructure how that power works if the belief is that there's just too much power for one person. I'm not sure we're there yet.
Yep.
But that's something that we could think about, and that's something that Congress could at least try to think about now. There is some language in the Constitution, the vesting clause under Article 2, which does say that the executive power of the United States will be vested in the President of the United States. So we have to make sure that we deal with that. And in fairness, the Supreme Court has already dealt with that. That is, it's not that all power is exercised by the president. But if we start to think about how we divide the power, cool. Now, should we have one term? Well, that's an interesting one. What would a one-term president look like? Would we go with a 6-year term?
Right.
Or would we keep it at 4? Or would we take it to 8?
I'd go with the Larry Sabato idea of a 6-year term with a 2-year retention election. Have somebody win the election, get 6 years, and then the population decides whether or not that individual gets 2 additional years on an up and down vote. I think that makes sense, because so much, as you know, Hank, so much of presidential politics, we're in the middle of it now, presidential politics is campaigning and messaging and so on. So if you have one term, 6-year, but you give that person an incentive to continue on with an additional 2 or 3 years, that makes sense to me.
Now, what would that last 2 years look like?
Yeah, that last 2 years would be lame duck. I think it would be complicated, and maybe the answer is 5 and 3. But I like the idea of a retention election as opposed to a campaign election. And it may be one of the things, as you know, Hank, one of the things we would have to think about. The impeachment process is a disaster, right? The impeachment process simply doesn't work anymore because it's become a political tool. Maybe it's always been a political tool, but it was supposed to be reserved for high crimes and misdemeanors, not necessarily for disagreement about the way in which somebody like Secretary Mayorkas politically does his or her job. With the presidency, it's become a little bit of a circus. It's a legal, lawyer-based operation, impeachment. So if we're thinking about a single term, you have to have a better mechanism for getting rid of what I would describe as incompetent presidencies. But I'm frustrated, as you know, I'm frustrated by the whole notion of campaigning being the dominant portion of an elected official, Washington, D.C. elected official's job. And I got to think some way we can reform the Constitution to eliminate campaigning as the fundamental feature of American politics these days.
Yeah, it's a great point. Great question. Is the reform campaign finance reform?
Yeah.
Or is the reform something different? Now, one of the things we run into is, are we a cult of personality country? And certainly we're not just talking about the last few presidents, but were we a cult of personality country when George Washington ran? Now, I shouldn't even say ran when he ran, because he didn't really run as such. Folks just sort of knew. You just knew. Right. But whether you go back to JFK, whether you go back to FDR, whether you go back to LBJ, I guess anyone who goes by their initials, maybe they're a cult of personality.
Roosevelt, right?
So,
TR.
there you go. Yeah. No, so that's a big question: is what do we want the president to do? Why do we structure the president as we structure it? We require the president be 35 years old, 14 years resident, and a natural born citizen. What is it about those minimum qualifications that makes us say you have to have them in order to be president? And then, assuming you win the election, we give you all this power.
Right.
I mean, those are real questions. And how would we reform that? And is that a reform that we should do through constitutional amendment, or do we say the Constitution is a document that has political principles, and those political principles mean y'all figure it out?
Yeah, I like that. Let me insert a question from the audience. Mickey Hamill asks, why do we not do away with the Electoral College and have a direct popular vote? Always a classic. I've got an answer, but you go first.
It's a great one. It's in the Constitution, right? I mean, right. There really are a couple of issues that pop up. We do have, in theory, the possibility of doing a national popular vote. Folks are trying to jerry rig it in order to pull that off. But here's the main problem, I think. The Constitution is structured as though the United States is a union of states. And as a consequence, every election we have is a state election. Right. We don't have any national elections. Now, we can talk about federal elections, but every federal election is really a state election for a federal office. And as a consequence, when we think about the Electoral College, it's really 51 different groups of folks kind of getting together, and they're not even really getting together. They're just reflecting the popular vote of their state, putting Maine and Nebraska to the side. So part of it is inertia. Part of it is also just our conception of the United States circa 1788 was union of states. And as a consequence, every state has to be treated as the equal of every other state. And that feeds right into the Electoral College. There's one other piece. The Electoral College feels crazy. It's a little less crazy if you think of it like this. The Electoral College, from a number perspective, essentially provides every state with the same amount of power that they would have if the Senate and the House of Representatives had a joint session to pick the president. And while you may well say, why would we do that? Well, think about the president. The president is the executive. The executive, in some ways, is supposed to do what the legislature says. The legislature's job is to legislate, and the president's job is to faithfully execute the laws. So in some ways, you want a president who can work with the Congress. So if you think of it in that way, the Electoral College is not crazy. It just feels crazy to us because we think of the president as a national figure. But the president's really a federal figure. But I've talked too much. Go for it, Beau.
So I'm not a huge fan of getting rid of the Electoral College. I am a big fan of reforming the Electoral College, and I'll tell you a couple things. I'll throw a couple things out there that may seem a little wacky. So, a direct popular election, I think, is problematic in an environment in which we don't have things like a national day for election or some sort of light pressure to go out and vote, because it no matter what, it's going to reflect, as it currently does, the 60% or so on of folks who actually vote. So I'm for a modified electoral college based on congressional district, not based on state, right? So if you have congressional district, and you, just like Maine and Nebraska, you're in a situation in which you bring in more of the media markets swing districts become different than swing states. Right now, the two coasts are useless when it comes to the Electoral College. But if you bring in districts, California and New York can come back into play as legitimate places of contest. And ultimately, I've also said that people think this is crazy, but if you went with a popular election, I actually think there would be a group of lobbyists out there. Hank knows this argument that would contest a popular election, and not the least of which are the network TV stations that love the Electoral College, because a lot of their revenue comes in those interim commercial periods when they're just about to announce a state that closed its voting. And so if you had a popular election where behind, Lester Holt or so on, there's just a number going, that's not dramatic TV. That's not revenue generating TV in the same way that that Electoral College is. But I'd like to see congressional districts be the place which I think it's not going to happen, but Electoral College is always a popular. Let me ask one more formal thing, and then let's talk about rights a little bit. But the formal, there's a lot of talk, Hank, about federal court judges having fixed terms. Right now, they have lifetime tenure and fixed salaries. Joe Biden puts together his commission. The commission does work on and considers the prospect of 18 or 20 or 22-year terms for federal court judges. Tell me what you think about fixed terms for federal court judges. Give them 20 years or 18 years or whatever it is.
Yeah, it feels gimmicky to me. Now, it is completely unfair for me to say that, in part because the reason why it feels gimmicky to me is because we've always had life tenure for federal judges. We don't have life tenure for all state court judges, and some state court judges are elected. But here's what I mean when I say it feels gimmicky. I think the most popular notion is 18 years for Supreme Court justices. And the question is, well, why? And the answer is, well, because we have 9 Supreme Court justices. So if you have 18-year terms, then you will replace a justice every 2 years, and that will give every president two opportunities to replace somebody. And we say, well, okay, so I guess that means that if you have 10 justices, they'll have 20-year terms. We again are jumping off of the structure we already have. And in some ways, it's not one where we say, if we were writing on a blank slate, what would we do? There is a second piece of the puzzle that gets really interesting. And that is, so one, if someone happens to, God forbid, die in office, does that throw our numbers off? One. Now, people could say, well, we could have a way to serve interim instead of, well, we could. But if the point is that we want to have each president only gets 2 and only 2 per term, although if we had a retention election, that would throw things off as well. The other problem is, what happens when you get near the end of your term? If you are retiring from that position, that's one thing. But what if you're going to be 60 years old and you're going to leave the court? In those last couple of years, will folks be influenced by what they want to do on the other side when they're drafting their opinions? That, I think, is a real concern that folks really don't want to talk about. Right. If you were to get a couple folks who were 50 years old, many folks who are 50 years old on the court, serving until they're 68. I know that some people would say, well, that sounds kind of old. Well, it doesn't feel old if you've also been on the court where you've been paid a nice salary for the general populace, but not a great salary for a lawyer who would have been practicing. who spent a lot of their very, very lucrative years on the bench, people will start asking questions. So I've always been sort of a fan of the life tenure for some of those reasons. Now, if we're writing on a blank slate, maybe we would have 15, 20-year terms, but that would affect who we thought would serve on the court. And that gets interesting because it may well be that what would happen is, give me the 70-year-olds. Why? Because we know that when they hit 88, they will retire. But of course, we're going to complain from the time they're 75 on that, my God, they're too old. Right. So it's a messy thing. And part of it is, should we think about justices as having their own, let's say, having their own atmospheres? Or is the notion, start picking people more at random? Or do what some folks have argued, which is just have an entire roster of Supreme Court justices and just pick them. You 5 hear this case, you 7 hear this other case, so that you end up with enough of a ideological spread, but not a clear one, that you end up getting what looks like law out of the court instead of politics out of the court. Awesome. Because if what we're really worried about is that the court's too politicized, then let's fix that.
Yeah.
Because I don't know that terms will fix it.
Right. So let's turn our attention to what is arguably, at least in my students, undergraduate students, their most seductive, appealing, interesting part of the Constitution, and that's the additions, the Bill of Rights in particular. As you know, I mean, the history is pretty clear that the Bill of Rights was a concession to anti-federalists who were not going to ratify the text. Madison makes a campaign promise to propose constitutional amendments. He ends up originally proposing 19. They get consolidated down to 17. 12 get through the first part of the process. 10 get through the states. And now we have a list of rights. Hamilton is upset about the fact that this list of rights is, he describes it in various terms as dangerous or redundant and kind of silly. A constitution is itself a Bill of Rights, but we have a Bill of Rights. And the freedoms that are in the Bill of Rights, Hank, as you know, have come to kind of represent the pinnacle of our constitutional polity, right? I'm always struck by the fact that when folks go to the National Archives to see our great founding documents, they'll beeline to the Bill of Rights over the original constitutional text or the Declaration of Independence, because for some reason the Bill of Rights is seen, as I said, more seductive or whatever. So I guess my question is, what do you like about the Bill of Rights? What would you like to change? And what would you like to add?
Yeah. Couple pieces on structure was real interesting. Folks like Hamilton, their point was the U.S. government was an umbrella government. We already had states. So the notion was the federal government doesn't get any power that the states don't give it. And as a consequence, some folks argued the federal government will not be acting on individual citizens. So it's odd to have a Bill of Rights for citizens when we don't want the federal government to act on citizens at all. So you can kind of understand that some folks said, when you put in a Bill of Rights, now you're suggesting that the federal government will act directly on people. One, and number two, if you have a Bill of Rights, anything that gets left out must not be a right. So that's sort of the structural piece of the puzzle. Now, that's not how we look at it today. And there's a second piece as well, and that is the idea of what we call incorporation, which is the notion that the Bill of Rights, the rights in the Bill of Rights, not only apply against the federal government, but also apply against the state government. For a good 150 years or so, that was very contested territory. And indeed, in the early 1800s, I guess with the 1830s, the court said the Bill of Rights doesn't apply to states. States can have their own bills of rights. That's to say, the Bill of Rights does not act as a limitation against the state government.
Yeah, states could infringe on individual rights if it wasn't in the state, if it wasn't protected in the state constitutions.
Absolutely. So when people make that beeline, one of the reasons why they make that beeline is because the notion is, oh, that's where our rights are. Well, yeah. Now that the Bill of Rights is applied against state governments, yeah, that's where our rights are. So if you were to say to somebody, how do you feel about the First Amendment and, let's say, free speech at schools? Well, obviously, free speech at schools is a First Amendment right. Well, go back to the 1800s, and the response would be, well, no. If the school is a state-based school, then the state can limit your free speech rights because the First Amendment didn't apply. So all right. So all that being said, now we do realize if it's in the Bill of Rights, it almost certainly is going to be applied against the states. Okay. What does that mean for what we need from the Bill of Rights or from additional amendments? A lot of folks have talked about giving people an affirmative right to vote, an affirmative federal right to vote, because you can't find an affirmative right to vote in the Constitution.
Right. What
you find are limitations on how states can provide the right to vote. And I know there's some folks who go, I don't get it. Well, if we went back to the 15th Amendment, it says the right to essentially it says states can't discriminate with respect to the right to vote on the basis of race, color, or previous condition of servitude. It doesn't say you have a right to vote. It says, look at what the state does with the right to vote. And if the state gives the right to vote, then they can't discriminate on the basis of race, but there's no affirmative right to vote. Indeed, one of the things that Bush versus Gore told us was there's no affirmative right to vote for president. There's not even an affirmative right to vote for the electors for president. The reason why we are allowed to vote for electors for president and functionally have a presidential election is because each state tells its own citizens, you are allowed to vote for the electors for the presidency. So some folks have argued what we really need is an affirmative right to vote, which really means what we need to do is recognize that everybody should have the right to vote.
And let me add one more to that, and then we'll go to a question. I couldn't agree with you more. The affirmative right to vote is missing and necessary. I would, if we're in convention, I think there's no question that we would follow the lead of some of the states around the country and find an environmental right, some notion of right to clean air or healthful environment and so on that states have been practicing with, and the laboratories have happened at the state level. Their constitutions, a lot of them now have this environmental right. I think that would be in play. Some of the other ones that people think would be in play, like a constitutional right to privacy, modification of gun control, and so on, I think those would be so contested that we'd end up leaving a convention without making headway on those things. But I think environmental rights, right to vote, and so on, those would be added to the constitutional text. Let me get Kevin Gray in here 1 second, Hank. Kevin says, this is a great discussion, very thoughtful, but I keep getting stuck on the fact that we do not have Madisons, Jeffersons, Hamiltons, etc. in Congress today. So true, Kevin. I question whether we could amend the Constitution in today's environment with the 24-hour, 24/7 news cycle, social media polarization. Any thoughts? Kevin, I think I'll speak for a minute, then I'll let Hank speak. The answer is, you're right. It would be very difficult in the polarized environment for us to really sit down and, as Hank says, blow it up again. But I actually think we're missing opportunities to amend the Constitution because of, I don't know, are we frightened about proposals for amendments? And I would give some modest ones. You know, they may not sound modest, but the Articles of Confederation had a term limits provision. We should think about that. There are some modest changes that that we could make and amend the Constitution. One of the things that I would love to see, and it's going to be difficult, is amending the Article 5 amendment process, right? So it's just the bar is too high. Do I think there will be an amendment in my lifetime? I think there will be, but I'm not 100% convinced. And part of the reason why is not that we don't have the Madisons, Jeffersons, and Hamiltons in Congress, because I wouldn't put the Congress members in the metaphorical Philadelphia or Dallas or wherever we're having a constitutional convention in the first place. I actually think you gotta have constitutional delegates that are regular everyday citizens that either run for a position as a constitutional delegate, a convention delegate, or are chosen at random for a constitutional convention delegate. But I don't think that Congress members are the individuals who will redo the Constitution, because I think most of them would like to keep it the way it is. So I'm not sanguine that we'll have an amendment in my lifetime, but I'm hopeful.
So couple pieces, which and the question is so much fun. One is, you're still going to have to get the thing ratified, right? So even if we have agreement in the new Philadelphia or Dallas or wherever we want to put the convention, you're still going to have to get something that can get past 3/4 of the states. And I am not sanguine on that happening really at all, frankly, for really anything. I wish it would, and that would be awesome, but I kind of doubt it. Let me though push a little bit, and here's where we like to have a little bit of fun. Let me push on the concept of whether we have Madisons, Hamiltons, Jeffersons. Alexander Hamilton fought a duel. I mean, come on. You know, I mean, we have. I mean, granted, the Broadway play is awesome, but part of what's real interesting is that if you go back and see Lin-Manuel Miranda at the Obama White House talking about his concept, he said Hamilton feels like a hip hop guy because he caught beef with every other founding father. Now, if you take that and you go, oh, we got plenty of Hamiltons now, he was brilliant in a number of ways, but we have a lot of really smart people who frankly are playing dumb in Congress right now because they think it's cute. Mm-hmm. And you know, I say this because we went to the same law school. Senator John Kennedy from Louisiana plays stupid. The guy is smart, but for whatever reason, he wants to act as though he's just some kind of I'm just your old country lawyer. No, you're not. Right. And don't get me wrong, plenty of brilliant country lawyers as well. But the point is, you have people who don't want to be elite because our notion is elite's not cool, even though if you're a congressperson, in some ways we expect it. Now, that's something we do have to think about. I hear you, Beau, in terms of having regular people, but my guess is that when you say regular people, you don't really mean regular people.
I mean in the chambers of the world.
Well, because we're not talking about the Beau Breslins of the world, because you are not a regular guy. And that's one of the things that's actually kind of interesting out there is it's not that we have a problem with regular people. It's just that there are a lot of people who've been thinking about these issues for a long, long time. And those may well be the people who you want to have when it's time to think about these issues again. Do you want what amounts to a big jury? Right. Or do you want a group of people who are not elite by birth. That's not what we mean, but who have been thinking about these issues in a way that allow us to say they really have the country's best interest at heart, or they have Americans' best interest at heart. And let me be very clear, those are two very different notions.
Right.
Having America's best interest at heart versus having Americans' best interest at heart, very, very different. And I know some people would say, no, I don't see any difference. Oh, yes, there is. The idea of saving the republic and having the republic be a going concern, as opposed to saying we're running this thing for the people, quite different.
Right.
Quite different.
So let me ask, Michael Herring asks, what about amending the Second Amendment? We're getting into the nitty gritty here, and this is super controversial. So I'd love to see the Second Amendment amended. I'm not sure it's going to. Hank, what do you think about amending the Second Amendment?
We can amend it. The part of the question becomes, how clear do we need to be about what it's supposed to do? Now, frankly, my take is we're probably looking at amending it in a way that just gets it back to its actual original purpose. That is, the Supreme Court, in my estimation, has just gone off the rails with the Second Amendment. That is to say, the Second Amendment in context is understandable if you think about the need to protect the homeland against somebody. That is, if you go back and if you just read the Declaration, in fact, just read the first two paragraphs of the Declaration, then read the preamble to the Constitution, then read the First Amendment, then read the Second Amendment. If you read those things together, you will probably look up and say, oh my Lord, the Second Amendment is about arms, and the arms that it's likely about are weapons of war. Now, if we treat it as weapons of war, then the question becomes, how do we regulate? That is, now that we have a standing army, now that we have people who do the fighting, do people need weapons of war? The answer is almost certainly no. But there's also the question of whether you should generally have the right to self-defense. That can be found somewhere else in the Constitution.
Right.
So I think we could amend the Second Amendment if we like, but what we have to do is ask ourselves, not so much whether we want to amend the Second Amendment, but do we want to say to people, you don't have a right to self-defense. At least you don't have a right to self-defense with a gun.
Right.
If that's what we want to do, cool. Almost no chance that's going to actually be passed. But it's perfectly reasonable to try. It's also very reasonable to do what I call sub-constitutional amendment stuff, which is to say, can you fight hard enough so that the judiciary caves and says, we now interpret these words to mean something different?
Right.
What's called constitutional amendment outside of the Article 5 process. And that may actually be the closest thing that we're talking about. Figure out what it is that you really, really love and really want to get changed, and ask yourself, do I need a constitutional amendment, or do I need a judiciary that will interpret the document in this particular way? That may be the best we can do, because I'm not sure how many actual amendments are going to get through anytime soon.
Yeah, so that's a great lead into the next question from Kenneth Bailey, who said, is there real consideration on updating the Constitution, and would that be beyond political favor or for serious reasons, or outdated, and new ideas such as environmental concerns and others? In other words, is there real consideration? And the answer is yes and no. This is not just Hank and I are not just having a conversation that's rhetorical in nature or theoretical in nature. There's a lot more momentum for constitutional reform than when I first got into this business of studying constitutional reform. A lot more people are talking about it, and that's what gives me some hope that we might have some formal constitutional reform. That said, let's be absolutely clear, as Hank just said, that there is constitutional interpretation happening every day that is, for all intents and purposes, changing the fundamental trajectory of our constitutional journey. And that happens typically in the courts, but it doesn't always happen in the courts. And I'll give you an example that I always think is fascinating. So when I tell my students, when I teach constitutional law, inevitably we teach them about the relationship between the national government, the federal government, and the states, federalism, and the shifting power dynamics depending on who's on the court. So in a remarkable period of time, folks probably know this, in a remarkable period of time between roughly 1937 and 1992, for that almost 6 full decades, there was almost a unanimous sense among the Supreme Court justices that the federal government would have control over things like regulating interstate commerce. And then all of a sudden, the guns in schools case comes up, US versus Lopez. And my students will generally ask me, what's the most impactful case ever decided in my lifetime? And I'm hard pressed to find one that's more impactful than US versus Lopez, where the court said, oh, no. Congress can't regulate guns in schools. That's for the states to regulate. That's a huge game changer, landscape changer of a decision. And so when we think about constitutional reform, a return to Philadelphia, it's really fun to think about that. And I think it helps us to understand what to be better Democrats. But constitutional change is happening, and dramatic constitutional change is happening every year in the federal courts and in the state courts, but mostly at the Supreme Court level. And we can't lose sight of that. I'll finish this tirade by saying elections matter. I tell my students that presidential elections matter, and it drives me bananas that that the media pays very little attention up until recently on how presidential elections will determine the fate of federal court decision making over the next generation. So when we think about how Americans can influence the trajectory of our constitutional path, it is through elections mostly that we get to have our say on who's making these dramatic constitutional changes. Hank?
Absolutely, right. And we can have real conversations about issues that are messy. So I recognize that the Dobbs decision causes folks distress on all sides of the issue, no question. But the issue of whether a certain decision should be made at the federal level versus the state level is an incredibly important question. And how you go about, or how a court goes about figuring that out for abortion today or guns tomorrow or something else, that very notion is important. Do we want to drive more power down to the states? Or do we want to push more power up to the federal government? Those are issues that matter, and those are issues that can come down to interpretive questions under the Constitution. It's not necessarily clear. And sometimes what can happen is those elections are the things that may drive power up to the federal government or drive power down to the state governments. And that's something that we've got to sort of think our way through. Another piece of the puzzle, of course, is what should the relationship between states and the federal government be? Right? We could say that states ought to be the equivalent. The states should be to the federal government what counties are to states. We could say that, but every governor would absolutely go berserk, because every governor believes I am the president of my state. Right? So I'm not beholden to anybody. I'm not like the county executive who is beholden to the governor, because counties are there to be administrative units. They're not there to have their own individual power, but states in our fundamental constitutional structure are there for that reason. So one question we can do is just talk about the question, what should a state be? What should a state do? When we go back to Vermont and say, there are only 600,000 of you, and you don't cover that much land mass either, why are you a state? Again, I'm happy for them to be one, but that's a question that we should ask. Why should 600,000 Wyomingings, but however they call themselves, I always mess that up. Folks from Wyoming, why should those 600,000 people in that state be called a state when arguably they're just a group of people who happen to be on a certain plot of land? Those are some of the things that we should be thinking about. And if we solve those problems, some of the other constitutional problems may fall into place. They may not, but they may fall into place.
So let me ask you two, I think, related questions, both of which I think are unfair, but so you might just punt them. But one question I have for you, these are the two questions. You can choose either one or both. Would you ratify the Constitution as is today? And secondly, what is your advice for the everyday citizen about how they can influence constitutional reform measures? What's a way in which folks who are listening can get involved in constitutional reform questions? So, would you ratify the text today? And what's your advice for people like me?
Yes, I would. On the question of ratifying the Constitution, as opposed to what?
Well,
right.
Yeah, that's tough.
Right, and that's always the question, right? Is
right.
If it means that we no longer have a Constitution, then sure, I'll take it.
Yeah.
But if I could then say, well, can I make changes? I might. And one of the changes that I might make, and this is a little messy, is I would amend the amendment process to require that when the Constitution is amended, that we re-ratify the entire document. Because that's one of the things that has run into a problem is we call it amending the document, and we just add language to the end of it.
Right.
That is the strangest way to amend a document that seems to exist. We would never tell a student with a draft, okay, you need to amend your draft. Just add language at the end, and try to make it kind of clarified. No. Redline the thing and renew it, because what that also makes us do is think about what those old words mean.
Right.
It also allows us to say, oh, when we're adding this information or we're adding this piece, that may change what other pieces of the document mean. And we should be clear about that rather than leave that to the Supreme Court to try to figure out. So that's what I do in terms of the ratification.
Can I insert before you answer the question? Yes. Can I insert one little footnote to that, which I always think is hilarious, and my students are always think this is wonderful. As you know, Madison, when he proposed the Bill of Rights, he intended for them to be inserted in the text itself. They were not meant to be additions to the end. He ends up losing that battle, but he wanted them to be inserted in the text. And that's why one of the things that I think is remarkable is that Americans, for the most part, will automatically think the First Amendment is first among equals, right? It has the great, the great pillars of liberty, free speech and freedom of the press and so on, freedom of religion. This is supposed to be the greatest of all. Of course, it was Madison's third, because it fit neatly, much more neatly in the Constitution, lower down, and the first two just didn't get ratified, and so our First Amendment becomes the first only by default. but Madison did not see, he agreed with you. He thought it was really awful and potentially damaging to the text to just have this group of additions at the end. Anyway, so that's
absolutely. I mean, you know, if we look at the 10th Amendment and the Supremacy Clause next to one another, it would be better if you wrote them together.
It makes sense.
Absolutely. You know, and it would clarify things a little bit. But I did not get to the second question. Remind me the second question.
Yeah, so the second question is, what do regular citizens like Beau Breslin do if if a return to Philadelphia/Dallas is not in our future? What can we do to kind of enhance democracy without constitutional reform, or push for constitutional reform? And
Yeah.
I ask you this question unfairly because it's a tough question, and I'm not sure there are easy answers.
It is a tough question, but let me give you the inside out way of thinking about it. Go to your local government and make some noise. Anything you want changed, get it changed. Anything you think ought to be different, get it changed. Anything that you have a complaint about, complain about it. The reason why I say that is because a lot of the constitutional cases that come up from local government, and the Supreme Court has to make a decision. And when they do, their decision doesn't just affect the locality, it affects everybody. So when you think about prayer at public meetings, came up through a local circumstance where somebody said, I don't like the fact that they don't have prayers from a diversity of pastors. Well, that case then trots up to the Supreme Court, and the Supreme Court makes a determination that either you have to have a diversity of pastors or you don't. But the rule that they put out there is a rule that then applies to everybody. So you can make new constitutional law, at least when it comes to constitutional doctrine, you can do that from anywhere because it can bubble up from anywhere. Rarely do you have a case that's just a nationwide case because it's got to be an actual case. So you're almost always going to have a small issue that ends up being something that the court opines on for purposes of everybody else. So I would say, particularly if you think there's no chance we're going to have constitutional amendments, go for it and do it at the local level and see what you can do. And that may well be a great place for folks to work their muscles. Obviously, their mental muscles. We don't want riots, but to work their muscles in terms of coming to agreements, right, and also disagreeing appropriately, in part because people think it's a smaller place.
Right.
So that's what I would tend to say to folks. Also think about going to state legislatures. They are much more accessible, particularly in reasonably sized states. They're much more accessible than one can imagine, and they're actually responsive. So that's probably where I would do my constitutional work. It would have to be, let me get the court to make a new constitutional rule or interpret the document differently. That's where I think most of the action really is at this point.
And I might add, I think that's great. Those are great suggestions. Great answer. I might add what I say to students all the time. It seems so simple, Hank, but the reality is elections do matter. And, you know, the fact of the matter is we can make change, not easily, but we can make change if we think about reminding folks that elections matter when it comes to not just Supreme Court and other federal court appointments, but also in terms of holding Congress members accountable. As I said before, and as you talked about with Senator from Louisiana, the reality is that a lot of Congress members like how comfortable they've become on the sidelines for a lot of the political action, and frustration can be alleviated through elections. And so let me thank you, Hank, before I turn it over to Jenny, for a wonderful conversation.
This is good. This is good, fun stuff. Let me just mention one small thing in terms of elections mattering and our students. our students, some of whom are getting some relief from President Biden, that is just $10,000-$20,000 taken off of their loan balance because of an election. Those things, for good or for ill, those things matter. On the flip side, obviously, lower taxes, those things matter, dollars in pocket. So think about those notions, and it does. Elections really do matter.
Quite true. Beau and Hank, our most sincere thanks for sharing your time and your wisdom with the NFRPP audience tonight. No doubt this topic warrants continued conversation, and we hope you'll return for a future program, maybe in the fall.
Yeah.
Sure.
We're super excited to do so, and we'll focus our attention, Jenny, on the election. Then when we come back in September, October, something like that, it'll be a great conversation.
And I would say, at least for me, don't be afraid of me. You can find my email if you just want to hit me up and have a conversation. That's fine too. Doesn't bother me.
Great. So I think in the meantime, if continue the conversation at home with Beau's book, A Constitution for the Living, imagining how 5 generations of Americans would rewrite the nation's fundamental law. It's available probably through your local bookseller, and it builds very much on tonight's conversation.
Makes a great gift too.
There you go. There you go.
I'm just saying.
Check's in the mail, Hank.
These are very productive sessions. So I hope our audience will join us on Thursday, May 2nd, and also Beau and Hank, you're welcome to come too. We'll be discussing taxes and what we all need to know. The NFRPP website is a great resource for our schedule of future events and our extensive library of this and all of our past programs. Please watch your email for a brief survey on tonight's presentation. We do use your input to shape future discussions. Thank you all, and see you on May 2nd. Beau and Hank, thank you again so much. Good night, everybody.
Thank you, everybody.
Thanks.